didn't get a chance to get a haircut. Now I'm on video. All right. I hate these videos too because I see them every now and then. I'm like, God, do I really look like that? And I think the one video I literally, I think it was 230 pounds. I was a big old fat guy. Anyway, all right. So I'll just leave that open to you guys. It's real important that you reach out and let me know how you do. If you didn't make it, then we can sort of try to coordinate something, and I will sit down and do a one-on-one. You guys aren't like a huge class. Johanna, I sat down with her and did a one-on-one with her, and she passed. So, but we spent a good 2 hours. So hopefully, if you need it, we can do it. So don't feel like, oh shit. All right. This is being recorded, so don't ask me to repeat, and unless you didn't, like that sounds mumbled. I'm not sure it was picked up on the tape. Then maybe I'll repeat. But if you're like, I didn't hear that or get it, I don't have time for that. I don't have time to explain why things are the answer. I don't have time for that either. It's just the damn answer. Okay. Why is that? Why would they do that? Couldn't they do it? Like, we don't have time to debate the wisdom of answers. Okay. All right, so I'm going to look at the outline. You guys were sent this outline with some material attached to it. You got really two things. You got a national exam outline. What it does is it has each topic and where it corresponds into modern real estate practice on what page. The state exam, you've got that outline, and you've got some of the handouts I gave you and some new stuff that I handed to you. So we're going to sort of go through that, and it was emailed. How many people got it? Okay, how many people didn't get it? Okay, did your emails change? No. Shoot me an email. I'll forward you, and hopefully, maybe you're.
On Monday. That's the one you're talking about, right?
Okay. All right. Well, I'll resend it. Just you two need to send me an email so I can. If you don't get it, I can resend
Can I
it.
use a copy machine? I'll just copy hers.
That's the outline. I think.
Well, there's a bunch of stuff. Like this state thing is a lot of stuff. I mean, if you want to copy it, that's fine. I'm gonna jump into it. All right.
Can I just copy yours? Do you care?
All right. So looking at duties and powers of the Real Estate Commission. One of the things that jumps out to me is there's a guarantee fund reference there. There has been questions on the state exam about the guarantee fund. One of the questions is, how is the guarantee fund initially funded? And the answer to that question is a one-time payment of $25 paid at the time you first get your license. That is how the guarantee fund is funded. A one-time $25 fee you pay when you first get your license. Another guarantee fund question is, what happens if the fund goes below $250,000? So the minimum balance of the guarantee fund must be $250,000. If it goes below $250,000, the answer to this question is, at the next renewal, each licensee pays a pro rata amount to bring the fund back to $250,000. At the next renewal, each licensee pays a pro rata amount to bring the fund back to $250,000. So if the fund goes to zero and there's 250,000 licensees, at the next renewal, each will pay $1 to get it back to $250,000. Licensing requirements: know what it takes to be a salesperson. That's been a question. So you've got to take and pass the 99-hour pre-licensing course. Then within 1 year of passing the course, you must pass the state and national exam. So that's what it takes. You must take and pass the 99-hour pre-licensing course, and then within a year of passing the course, you must pass the state and national exam. couple of questions, disclosures and things like that. So, one of the disclosures is, let me just think of the one that, well, let's talk about psychological impacted property. So know the two categories. The first category is the property is the site of a homicide, suicide, or other felony except arson. So arson is not a psychological impact. The other psychological impact is the occupant of the property has AIDS or HIV or some other disease that medical science has determined cannot be contracted through mere occupancy. So it's going to be like an AIDS or HIV question. That category is completely confidential. So the first one, homicide, suicide, or other felony except arson, if the seller's agent is asked about that, they must answer that question truthfully. Now that question must be in writing. So if the buyer says, hey, we heard somebody hung themselves in the bathroom, that must be in writing for them to get a disclosure about it. There's no duty to disclose unless it's requested in writing. There is no duty to do further inquiry and research it unless the buyer asks the seller's agent to ask the seller. That is the extent of further inquiry. In writing, the buyer must ask the seller's agent to ask the seller, and then the seller would have, the seller's agent would have a duty to ask the seller. With the last one, HIV and AIDS, whether they ask in writing or not, it's not disclosed, okay? All right, let's see. Consumer information statement. A couple of questions about that. When must it be provided? It must be provided to the consumer no later than first schedule appointment or showing of a property. So that's when the CIS, the Consumer Information Statement, must be provided. Must be provided to the consumer no later than the first schedule appointment or showing of a property. Another CIS question is, what must be made available at an open house? That's the question. What must be made available at an open house? The answer to that question is the Consumer Information Statement must be made available at an open house. All right. Handling of documents. There's been a question on who must get a copy of whatever agreement it is. If it's the agreement of sale, the rules basically require the parties to the agreement must get a copy. So if the question is, under the commission rules, who must get a copy of the agreement of sale, the parties to that agreement are buyer and seller, and that's it. That's what the commission requires. If they ask you about a listing agreement, who's the parties to the listing agreement? That's the listing agent, the seller's agent, and the seller. Okay, so if you get a question, who must get a copy of whatever agreement it is, just evaluate who the parties are, and that's who must get a copy. Again, like the agreement of sale, your answer choices might be buyer's attorney, buyer's agent, lender. Under the commission rules, they aren't required to get a copy. The commission rules just require the parties to get a copy, and the parties to an agreement of sale are buyer and seller. All right, handling of money. Now, there's several questions dealing with handling of money, like deposit money. So how much, one of the questions is, how long does a licensee have to deliver the deposit money to their broker? Okay, remember the broker is the only one that can deposit the deposit money. So the answer to that question is immediately. Now, if you look at the rules, it says promptly. I think promptly and immediately are different, but on the test, Dave uses the answer immediately. Another question about depositing money is, how much time does the broker have to deposit the money? And that is 3 business days. Another disclosure thing deals with, this one shows up. It's a question that deals with, you are marketing the property as a listing agent, and you're saying, hey, if I can't sell your property, I guarantee to buy it. So that's your little promotional ad on some radio spot or something. If you're doing that, then the rules require that in the listing agreement, you must set the price. And then under the commission rules, you are required to close within 60 days of the termination of the listing. So that's actually the question on the exam. How long does the listing agent have to purchase the property if he's had a promotional ad that says, if I can't sell your property, I guarantee to buy it? The answer is he's got 60 days from when the listing is terminated to purchase. Okay. All right. Presumed agency. The presumed agency in Delaware is statutory agency. All you are is an independent contractor with statutory duties. That's what you are. All right. Let's see here. What else do I have? All right. So let's sort of go through this little outline page here. So the first thing is wind energy deed restrictions. There's a question apparently, or at least on the outline, that talks about wind energy thing. I don't know what that question is. I just gave you the whole wind energy deed restriction statute, so you should have that. I don't know what the question is about it. This next thing, basic DENREC rules regarding septic systems. The two things that you need to know is number 2 and number 5. So the pump out requirements is how often must you pump out your septic system? The answer is every 3 years. Another question is, has something to do with the transfer requirement. So DENREC rules, this Department of Natural Resources and Environmental Control, DENREC rules require that a property being sold that's on a septic system be inspected and pass inspection to allow for the transfer. Now, what the DENREC rules say is if the property was inspected and passed inspection within the last 36 months, that's what it says, 36 months, not 3 years, 36 months, which is weird. Because the pump out requirements is every 3 years, and then this one is every 36 months. I don't get it. But it says if it has been inspected and passed inspection within the last 36 months, that inspection will count to allow for the transfer of that property that has a septic system. So property on a septic system must be inspected and pass inspection before it can be transferred. If it passed an inspection within the last 36 months, that inspection will count to allow for the transfer, okay? All right, the next one is resale certificate basics. Now this covers every question so far that Dave has asked about DUCIOA, the Delaware Uniform Common Interest Ownership Act. Now, if he gets a little complicated, the act applies to common interest communities that were created after September 30th, 2009. It actually applies to some created before that, but generally it's condos, co-ops, and what they call planned communities, which are like a subdivision. Okay, so communities that have common interest ownership like open space, stormwater management, ponds, tennis courts, workout facilities, that kind of stuff. So in this, it tells you what's in the resale certificate. So I'm not going to regurgitate that. I'm just going to sort of go over questions that I've been made aware of. So one of the things, the first question is, what is not included in the resale certificate? So you'll see here in bold, does not include number of units being leased/rented. And then in parentheses, which is now the change to the new answer, does not include number of units that are non-owner occupied. It's the same thing. It's just Dave being weird. So look, if you own a unit and you don't live in it, chances are you're leasing it, right? So his verbiage is kind of just being tricky here. So what's not included is the number of units that are non-owner occupied. That's really useful information. It's just not in the resale certificate. So I don't want to go into why it's useful, but it's not in the resale certificate. So question, what is not in the resale certificate? Number of units that are non-owner occupied. Another question is number 3, time for furnishing. So the question is, when must the buyer furnish, when must the seller furnish the resale certificate to the buyer? No later than time of execution of the agreement. Now there could be a question, what happens if it's furnished after the agreement's signed? The buyer gets 5 days to cancel after receipt of the resale certificate at any time before transfer. That's where I think Dave could get tricky. If you get the resale certificate the day before closing, you don't have 5 days to cancel because you must cancel before transfer. You get 5 days, but at any time before transfer. So if you go to closing and you think, well, I got another 4 days, no, you don't. There was a transfer. So you get 5 days after receipt to cancel, but before transfer. Is that making sense? Like the day before closing, you really have that day to cancel, because once you go to closing, you can't cancel, okay? All right, next thing. When must the association furnish the information to the seller? So the seller lives in a community, he must give a resale certificate, and he gets this information for the resale certificate from the association. When must the association provide that resale certificate information? Within 10 days of request. Another question is, how much can the association charge for the resale certificate? They can charge $200. If you require it to be in a paper format, they can charge you $250. Now, another question is, what happens if the association furnishes the information after the 10-day requirement? They can't charge you for it. So they must provide the information within 10 days of request. If they provide it after the 10 days, they can't charge you for it. And then the last question on the exam is, how long is the information, the resale certificate, good for? The answer is 120 days. It's good for 120 days. The other thing attached is the co-ownership comparison chart. I don't know of the questions he might ask you about that, but you have it there. Now, there has been some questions about joint ownership that are actually kind of stupid. It sort of illustrates the nonsense of why we teach you this stuff. So the question is, hey, you represent a boyfriend and girlfriend, you're their agent, and they ask you, what form of co-ownership would you recommend? And in your choices would be tenants by the entireties. Well, that can't be it. They're not married. Tenants in common. Well, I can do it that way if they want. Joint tenancy, they can certainly do that. And then the last choice, tell them to consult with an attorney. That's the answer. Tell them to consult with an attorney, because you can't give legal advice because you don't have a license. You're practicing law without a license. All right, this next thing in the handout is the co-owners, or try again, the protected classes. So we have a federal fair housing law, we have a state fair housing law. And the state fair housing law protects classes that the feds don't protect. So these last set of classes, these are the classes that Delaware protects, so above what the feds protect. So the question is, what classes does Delaware protect under their state fair housing above the federal protected classes? So you can see where they're identical, and then the ones that Delaware protects above that is creed, marital status, age, sexual orientation, gender identity, and source of income. Source of income is a protected class. A landlord can't refuse to rent to you because you're on welfare, okay? So the classes that Delaware protects above the feds is creed, marital status, age, sexual orientation, gender identity, and source of income. Now, another question on the exam, somewhat related to fair housing, is this stupid question that Dave put on based on an email I sent him. Because I figured out there's a problem with our code, and he turned that into a question. So under our Delaware landlord tenant code, they list a protected class called occupation. Occupation, though, is not listed in the Delaware State Fair Housing Code. Those things should be identical, but the Landlord-Tenant Code lists occupation for whatever reason. It's a mistake. It should actually either be added to the State Fair Housing or taken out of the Delaware Landlord-Tenant Code, because those need to be consistent. It's sort of redundant to actually put it in the Landlord-Tenant Code, because fair housing applies to rentals, so it's stupid, but it's there. So here's the question. What is a protected class under the Delaware Landlord-Tenant Code that is not a protected class under the State Fair Housing Code? You're going to circle occupation. Okay. More fair housing questions. Where do you go to report a state fair housing violation? And that's the State Human Relations Commission.
What's
No.
it, state? Human
State,
Relations?
you're asking me to repeat. I said I don't do that. State Human Relations Commission, because Chris is taping this, all right? Now, how long do you have to make a fair housing violation complaint? You have 1 year from the alleged discriminatory practice. Okay, for whatever frickin' reason, there's a bunch of questions about tax ditches. Like, you will never, ever, ever talk about tax ditches, ever. You'll barely even see it, and if it comes up, it's the lawyer dealing with it, not you. What the hell are they asking a shit ton of questions about tax ditches? So, in your material, actually, I'll get to that in a second. Let's do the sign law. So we have I guess a law, sort of. DelDOT does not allow you to place signs within the clear zone. The clear zone is a 10-foot area from the paved surface. You got to be outside that clear zone to post your sign. So there's a question, where must you post your signs outside the clear zone is the answer to that question. He did 1 year say, what is the clear zone? 10 feet from the paved surface, okay? That's all in this here. I hate to admit, but it literally took me years to figure out the answer to that question. Students would say, hey, we had this question, like, where do you place your signs? And I'm like, let me go look at that, because I really don't know. And I'm looking at zoning laws and blah, 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 blah. And one of the common things that kept coming up was this clear zone thing. Now it's in the actual outline. So I Googled signs in clear zone, and I found this thing on DelDOT's website. And it's a diagram, and it shows what the clear zone is, and then little, like, don't put your sign there kind of bullshit.
That's your for sale sign?
Right, so that says, oh shit, outside the clear zone is the answer. That is the answer. All right, so now tax ditch stuff. So this is a blurb from DENREC regarding tax ditches. So there's a couple of questions on the exam about a tax ditch. What the hell is a tax ditch? A tax ditch, if you read this, it says is a government subdivision of the state formed by prescribed legal process of Superior Court. You actually petition communities that benefit from drainage ditches. A petition is filed to create a tax ditch district. And then all those communities that benefit from drainage into that pay a tax for the maintenance of the tax ditch. The other thing that it creates is an easement over and along the tax ditches. So these are drainage ditches. So there's easement areas that run. So it does two things. It creates a district to tax the people who benefit from the ditch to pay for maintenance. The second thing it does is it creates an easement for maintenance of the tax ditch. So you can be in a tax ditch district and not have a drainage ditch on your property, but you benefit because you drain over several properties into a ditch. So you could be in a tax ditch and not have a ditch near you, but you drain over other people. So again, it creates a district in which you pay taxes for the maintenance of your drainage ditch, and it creates an easement along the drainage ditches for the maintenance of those ditches. Now, a question is, who's responsible for the tax ditches? Well, it's created by a petition, and the petition then sets forth a group of people called tax ditch managers. The tax ditch managers govern who is responsible and how much is paid for the maintenance of the ditches, tax ditch managers. And then the last question about tax ditches, which just seems insane to me, all these questions about tax ditches, is where do you get information about tax ditches? There are 3 spots. DNREC, the Department of Natural Resources and Environmental Control. The Prothonotary Office. Now you're like, Prothona what? Prothonotary. That is the clerk of the Superior Court. Remember, a tax ditch is a governmental subdivision of the state formed by a prescribed legal process in the Superior Court. So who's the clerk of the Superior Court? They're called the Prothonotary. Okay, that's another area you get information about tax ditches. And then the last spot is the Recorder of Deeds. Properties that are subject to tax ditches, the ditch must be recorded at the Recorder of Deeds office. Okay? All right. I guess there possibly is one more thing. A deed where the property owner or the grantor in the deed is subject to a tax ditch, that deed must reference that the property is subject to a tax ditch. So the grantor, a deed from the grantor must reference if it is subject to a tax ditch and specifically reference the tax ditch. So maybe that's something. The only reason I'm saying that is I was involved with Dave when we did the tax ditch bullshit. Now it's a question. Jesus Christ, don't get me started. Hi. He pisses me off. All right. Okay. On the outline, it talks about solar panels and deed restrictions. I don't know what the question is. I gave you the whole damn deed restrictions solar panel thing. The upshot is deed restrictions can't prohibit solar panels. They can create restrictions, but they can't prohibit them. So they can, provide for, certain things that will, screen it a little bit or where they can be located. But the bottom line is if they have to be oriented a certain way, they got to be oriented a certain way. Okay, now this next thing is vehicle services titling. Okay, this deals with mobile homes. Okay, so the first thing, what does it take to convert a mobile home from a motor vehicle to real estate? The short answer is by retiring the title. Now that's been both a state question and a national question. It's the same answer, retiring the title. Retiring the title is a simple process. You go to the county and they come and inspect the mobile home to see if it meets building code requirements. One of the building code requirements is it on a foundation. Okay, that's one of the things. And then if it does meet building code requirements, the county submits a report that gets to motor vehicle, and motor vehicle retires the title. When title to the vehicle is retired, the mobile home is now considered real estate. Okay. Now, this is absolutely frickin' insane. What is the transfer tax on the transfer of a mobile home? So when it's a vehicle and you're transferring the vehicle, am I like crazy? Like, aren't you guys like going to be realtors dealing with real estate? Like, and I'm sure a bulk of what you do is going to deal with frickin' mobile homes. Seriously, if you deal with one mobile home in your lifetime, maybe. And if you do, what are you going to do? Hey, Raj, I don't know what the frick I'm doing. I almost said the F word, but I'm being taped and I have to be careful about that. Because God forbid Maureen is playing this in front of her little ones, and you know how little ones hear dirty words and they just know they shouldn't say it, and they say it all the time. Like my oldest daughter, when she was young, like 3, she loved to say shit. She says shit all the shit. We're like, stop, shit. She just loved to say it. All right. So, the transfer tax on the transfer of a mobile home, the transfer of the vehicle, is 3.75% paid by the owner. How silly is that? I gave you copies of this stuff out of the code. All right. I don't know. It's a long-ass statute, but according to this outline, the Uniform, what the hell is it called? The Uniform Electronic Transactions Act. I don't know what a question you are going to get. Probably it'll be simple. The basic thing is you can do an electronic transaction where you sign everything electronically. You can do that if all the parties in the transaction agree. Then it becomes subject to this Electronic Transaction Act. Beyond that, I don't know what they're going to ask you about it. I couldn't tell you. All right. All right. Let's talk about deeds. Well, we got a few more. Okay. So the standard typical deed in Delaware. That's a question. What is the standard customary deed in Delaware? That's special warranty deed. Another question is what deed? Well, the first question used to be, what deed provides the buyer with the least amount of protection? And that was the quitclaim deed, because he got no warranties, right? Quitclaim deeds have no warranties. Now, Dave has asked that question now in a weird way. What deed exposes the seller to the least amount of liability? Well, that's the deed where he gives no warranties. He's not sticking his neck out. So the deed that exposes the seller to the least amount of liability is the quitclaim deed, okay? What deed exposes the seller to the greatest amount of liability? That is the general warranty deed. Now, the old question was, what deed provides the buyer with the most protection? That's the one where he gets the most warranties. Correspondingly, it also opens up the seller to the greatest amount of liability because he's giving the greatest amount of warranties. So, I don't know where all that comes from. Okay. Questions about surveys and legal descriptions. What is the typical method of describing real estate in Delaware? And you're going to circle meets and bounds description. Okay. Now, there's a question about surveys. I know it has to do with the way that each of the three counties deals with surveys. So I don't know this specific question, but I'll just tell you how the three counties deal with it. So in Newcastle County, you can do a survey without it being staked or the corners set. It's the same thing. I don't know what phrase Dave uses, but setting corners or staking corners is not required in Newcastle County for a survey. In Kent and Sussex, if you order a survey, the surveyor is required to set the corners and stake the corners. Even if you don't ask, they are required to do it. They are not allowed to do a survey without setting or staking corners. In Newcastle County, surveyors are allowed to do it. The question about home inspections, something to do with somebody doing a home inspection, must they be licensed? They have to be licensed through the Delaware Board of Home Inspectors. They are not allowed to do home inspections unless licensed through the Delaware Board of Home Inspectors. All right, let's see what else here. Talked about fair housing, title, surveys. Oh, transfer tax questions. So one question is, what is the maximum transfer tax in Delaware? Now, that's 4%. It's 2.5% to the county. Try again. 2.5% to the state, 1.5% to the county. Now, there has been a weird question. I know it's a weird question, just nobody seems to know what the question is, but I'm pretty sure it has to do with this scenario. What the state transfer tax code says is you'll pay 2.5% or the difference between what the local taxing authority taxes to get the total of 4%. So what the hell does that mean? Let's say there's a jurisdiction in Delaware, and I think Clayton used to be this. So Clayton charges a 1% transfer tax. So you're in the city of Clayton, so you're not going to pay Sussex County or Kent County transfer tax. You're going to pay Town of Clayton transfer tax. Clayton charges 1%. So the state, instead of charging 2.5%, charges 3%, because they make up the difference to create a total of 4%. So it always will be 4%. Unless there's some other first-time homebuyer exemption or something like that. Now, transfer tax exemption questions. Or no, who pays the transfer tax? Customarily half by buyer, half by seller. Okay, so know that. So they're split. Then transfer tax exemption questions. A transfer between a parent and child is exempt from transfer tax, even if there's a purchase price paid. So mom might say, hey, kid, you want my house? You pay me $200,000 for it. You're not going to pay a transfer tax, even though mom's making you pay for it. It's a transfer between a parent and child, it's exempt. And vice versa. If child is transferring to parent, it's exempt. A transfer between a grandparent and a grandson is not exempt. And he asked this question in a very weird way. So Grandpa Joe is transferring to grandson Billy. The transfer tax is, and you're going to circle fully paid. That's just a roundabout way of saying it's not exempt. Okay? The old answer was half by grandson, half by grandpa. Well, if each is paying their half, it's fully paid, so it's the same answer. It's just kind of a weird way of going about it. Okay, let's see what else. Home inspection, we talked about that. There's been questions about the sale of a mobile home park. The Delaware Code gives the mobile home park residents a right of first refusal to purchase the mobile home park. So if the landlord is selling the mobile home park, he must first offer to the mobile home park residents a right to purchase the property, match the offer from the buyer that he has. So they have a right of first refusal to purchase the park. All right, let's see, we talked about that. What else we got to talk about? Seller financing question. So this deals with an installment sales contract. This is where the seller or the buyer is paying the purchase price in installments. When there's a default, the buyer gets 120 days to redeem. So the seller can't do anything when there's a default until the buyer, after 120 days. The buyer gets a 120-day redemption period. That is, you're in default, you get 4 months, 120 days, to go find the money to purchase the property. That's what redemption means. So 120-day redemption period. All right. Okay, let me just look here and see if I'm hitting all the really important stuff. Condo questions. You could get some condo questions where Dave is asking them in a very bizarre way. So if he says, under the Unit Property Act, that is a condo question. With a unit property, that is a condo question. So if he uses the phrase unit property or Unit Property Act, it's a condo question. That's our old Condo Act, okay? All right, now, some of the condo questions are what I consider fairly straightforward, but one of them is, how is your percentage interest in common elements determined? The answer is relative size. So a larger unit has a higher percentage interest than in the common elements. Smaller units have a smaller percentage interest. Another question is, with a condo, and it might just say, with a unit property, what do you own? And you're going to circle fee simple title to the space in the unit. You're probably like, well, yeah, so yeah. But remember, like if you owned a parcel of land, remember in Unit 2, you owned all the way to the center of the earth and everything out to the outer space, right? But with a condo, you just own the space in the unit. That's what you get. You don't get the stuff above it because chances are somebody's above you, right? Okay. Now, how is your voting rights determined? you're going to circle by your percentage interest in common elements. Remember, a larger unit has a higher percentage interest. Guess what? They get a larger voting block too. How are your dues paid? By your percentage interest in common elements. It's weighted by that. So a larger unit pays more dues than a smaller unit, okay? Now, condo insurance questions. Like, aren't you guys gonna be realtors and not insurance agents? So what the hell? Seriously, Dave, you make me crazy. All right, so break out insurance questions into two ways, okay? Liability and casualty, okay? Liability is injury to people. Casualty is damage to property. Then with a condo, there are two policies. The master policy, which covers the common elements in the condo association property, and then unit insurance, the condo owner's unit insurance, okay? So if somebody slips in the lobby of the condo building, that's gonna be covered by the liability component of the master policy. If the HVAC unit that services all the units in the building is damaged by a windstorm, that's covered by the casualty portion of the master policy. If you lit your stove up on fire and burned your cabinets in your kitchen, that's covered by your casualty insurance of your unit policy. If somebody at a party goes in the bathroom, slips and bangs their head on the toilet, that's going to be covered by the liability component of the unit policy, okay? So they're actually pretty simple. Some title insurance questions. Kind of basic, but just know this. Owner's title insurance affords no protection to the lender, and the lender's title insurance affords no protection to the buyer. They're separate. So an owner's policy does not protect the lender, and a lender's policy does not protect the owner, okay? Offers no protection. All right. Okay, good here. All right, so we talked about the surveys, we talked about the mobile home stuff, talked about retiring the title. Life of me, I couldn't tell you what that is. All right. So one question that came up, and it comes up a little bit every now and then, is you're representing a seller, and you come across something in the property that's a problem, and your seller didn't disclose it. You have a duty to disclose that to the buyer. Now, the way you should do this, though, and I think this is the way it comes up in the question, is you must first tell your seller to update the seller disclosure to reflect the new information, the new defect that has been discovered. That's what you first must do. So the question is, you come across an issue that's not disclosed on the seller disclosure, what must you do? Tell your seller to update the seller disclosure, okay? Now, there has been a question that kind of related to these kind of disclosures. It's different because it's now commercial property. So with residential property, you as an agent for the seller must disclose material defects that affect the property that you're aware of. Now, with commercial property, that doesn't really apply to a commercial realtor because of the nature of it. It's commercial. So the question was something like this. You're the listing agent for a property, and a highway is going in next door. So they're gonna put a highway in right next to the property that's being sold. Is that required to be disclosed? Can you disclose it? Can you continue with the listing? The answer is yes, you can, and you do not have to disclose it. Now, here's the reason why. This is one of the few times I'm going to tell you why. It's commercial property, and the defect is off-site. That's why. If it was something on-site, yeah, there's a duty to disclose it. But if it's off-site, like, hey, a monitoring well detected hazardous substance in the groundwater, and the property that's being sold is subject to public water. Well, who gives a shit about the groundwater on a well. I mean, it's off-site, it's not affecting the property, no duty to do anything about it, okay? So I think that's a really stupid question too, because you know what? The law isn't really clear in Delaware about that disclosure. So I don't really understand what Dave's getting at when it's not very clear. Okay, so there has been some questions about littoral and riparian, and I think all you're required to do is just know the difference. So littoral are water rights that you have by living adjacent to a navigable waterway. Riparian are the water rights that you have by virtue of living adjacent to a non-navigable waterway. Now, what could be asked? What is the boundary line between two riparian property owners? Well, that's a non-navigable waterway, riparian. So the boundary line is the center line of the watercourse. Now, littoral, I don't think Dave's going to ask you this because Delaware is different than national. But littoral is you live adjacent to a navigable waterway like an ocean. In Delaware, your boundary line is the mean low water mark. And throughout the country, it's the mean high water mark. So Delaware's mean low water mark is your boundary line. Delaware actually gives you more because it's lower, the average of the low tides. And that ain't much of a boundary line, but that's what it is. He hasn't asked that question. I'm actually very surprised he hasn't, because that's like a weird thing of Delaware. We're different than other states, but he hasn't asked that. Okay, let's now talk about some potential TRID questions that you could get on either the national or state exam. Now, TRID, one of the questions, well, you may not, what the hell is he talking about, TRID? TRID stands for, well, let's back up. TRID is this new process by which we do closings. It's this rule that was proposed by the Consumer Finance Protection Bureau. So it fundamentally changed how settlements are done, okay? So one of the questions on the national exam is, what does TRID stand for? It's an acronym. So the T is Truth in Lending. The R is Real Estate Settlement Procedures Act. So T is TILA, Truth in Lending Act. R is RESPA, Real Estate Settlement Procedures Act. I is integrated, D is disclosure. So TRID stands for TILA, RESPA, Integrated Disclosure. That's a stupid question. Who gives a shit what TRID stands for? Dumb. All right. Now, one of the questions is, who is most likely going to, well, let's back up. Under TRID, each party gets their own settlement statement. That's called a closing disclosure. The settlement statement is now called closing disclosure. Buyer gets one, seller gets one. The question is, who's most likely going to prepare the buyer's closing disclosure? You're going to circle the lender. The lender is most likely going to prepare the buyer's closing disclosure. Who's most likely going to prepare the seller's closing disclosure? In Delaware, that's going to be the closing attorney. In the national exam, that's going to be the settlement agent. Another question you could get is, when must the buyer get their closing disclosure? And that is 3 business days before settlement. Now, I can't imagine they'll ask you this, but it's getting it 3 days before settlement. You're deemed to receive it if it's sent to you electronically on the day it's sent electronically. If it's sent by mail, you're not deemed to receive it until 3 business days after it's been mailed, and then the 3 business days runs from that. That's kind of silly. I don't think they're going to ask you that, though. All right, let's see. So that's the TRID stuff. Okay. Continuing education questions. So they've asked a few. What is the continuing education requirement for a new licensee? The answer is in your first year of licensure, you must have 12 continuing education credits. Another question could be, what is your basic continuing education requirements? That's 21 hours every 2 years. When do you renew? April 30th every 2 years. And you've got to have 21 hours of continuing ed within that last 2-year period. All right, now they have asked this. Somebody was saying, they asked a question about modules, and I don't know what the hell's a module. And I'm like, holy crap, I can't believe they're asking about modules. But I don't know what the question is, but the way it works is there are 7, your basic continuing education has 7 modules. Each module is a subject area. You must, with your basic continuing educations, have a course in each of those 7 modules. A course is 3 hours long, okay? 3 times 7 is 21, okay? So unfortunately, Chris didn't know that, but all of us do. That was a joke, Chris. Chris is ignoring me. All right. So modules, what happens is a course provider submits an outline to the commission to get approval to teach a course in a particular module. Hey, I want to teach a course in fair housing. And here's my outline. So I want to teach a course specific to Delaware fair housing. Here's my outline. And I think it's a Module 3 course. So then they look at your outline, see that it's 3 hours, and they see, does your topic fit in that subject? And if it does, they'll approve it for that module. So again, you can't take like 7 Module 3s. You got to take each module, okay? And then there's another question, how long must you keep your certificate? For 2 years, okay? You must keep your continuing education certificate. So when you take that course for that module, the course provider gives you a certificate of completion. And you keep those certificates, because then if you get audited, you can show that you've got your 21 hours of continuing education. Now, when you're talking about new licensees, they have 4 modules geared to new licensees. There are specific topics for new licensees, like agreements and some basic stuff. So each course is a 3-hour course in each of those 4 modules. 3 times 4 is 12. There's your 12 hours, okay? All right. So the module system, continuing education, all right. Okay, then some of the oldies but goodies. The lake question. Guy owns 2 parcels adjacent to a lake. He sells both parcels. What is the best way for him to reserve a right to cross the parcels to get to the lake? Easement and gross. Easement and gross. He can't create an appurtenant easement because he doesn't own any parcels to benefit the parcel. It's just him. So you can only create an easement in you individually as an easement in gross. A license would work, but it's not the best because a license is revocable. It says what's the best for him. The best is non-revocable, which is easement in gross. If you understand that's why, why it's the answer, great. If you don't understand why it's the answer, and just circle easement and gross, and who gives a shit, right? Okay. Now, the other infamous question, the oldie but goodie. Husband and wife own property as tenants in common. That's weird. They would normally own as tenants by the entireties, but it spots you as tenants in tenants in common. Husband dies without a will, survived by his wife and 2 adult children. Who signs the listing agreement? That's really a question that says who has an ownership interest in the property. So the answer is the wife and the 2 adult children have an ownership interest, and I'll explain why, and then I'll be done. All right, so when husband passes, wife, because there's no right of survivorship in tenants in common, wife retains her half interest. Husband half interest goes under the intestate succession law of Delaware. Dies without a will, right? Intestate succession. Under Delaware's intestate succession law, real estate goes to the surviving spouse as a life estate, and if they're children, the children have remainder interest. So wife gets a life estate in the other half interest, and the children are remaindermen to that half interest, so they have a future interest. So if mom passes, then the kids will become the owner, so they have this, what they call